we start with an interview. It's usually a very short interview. We've got paperwork to have all of our clients fill out, and that kind of lays the groundwork for what ultimately will become the decree of divorce and what will ultimately become the property settlement agreement that comes with that. So, as you can see, our divorce forms are pretty extensive, and they should give us a pretty good feel for what the property interests are at issue and how those things are going to be divided. It's very, very important that we understand every last bit of any agreement that has been made by the parties. The big pitfalls that we sometimes see on these forms is that either the person that's coming to us or the opposing party or whatever it may be simply doesn't understand what they are entitled to in the state of Arkansas. So I want to go through a few of those things right now. First, let's talk about grounds. Arkansas does not have a no-fault option for a divorce, with the exception of people who have been apart for a period of greater than 18 months without cohabitation. That means that we have to look at what the opposing party has done to cause the divorce. It's not as complicated as it sounds. It doesn't have to be cheating. It doesn't have to be drug use. It doesn't have to be anything like that. The strictest term is general indignities, which is a course of conduct that renders married life intolerable. In short, that means basically anything. The reason why a marriage falls apart in the first place is probably going to be adequate for the purposes of general indignities. So don't be afraid that you're simply not entitled to a divorce in the state of Arkansas. That's generally not true. The next issue that I want to talk about is custody. Arkansas has a preference towards joint custody, but that is not required by any stretch of the imagination. We can help you through making a viable custody and visitation schedule in any manner that you would like. And along with custody is the issue of child support. Arkansas has recently changed their rules on child support, and it's complicated. However, we here at the Troutt Law Firm are more than happy to help you out with making that analysis. We would need to know both parties' gross incomes, and there's a few other variables, but we can at least provide the number that would be in line with Arkansas law. Within reason, varying that is generally acceptable, and it can also be varied based on the amount of time that one party or another has with the minor children or child. The next issue is property, and the good news is that Arkansas law is incredibly simple on that. It is 50-50 of all property acquired during the marriage, plain and simple. There are exceptions to that, but don't worry about them in the context of an uncontested divorce. Does that mean that you have to do 50-50? No, it absolutely does not. And realistically, some things are more valuable for one reason or another to one party than another. But with all of that aside, I want to move on to how exactly going to court on an uncontested divorce works. First, after all of the documents are signed by both parties, the complaint gets filed. Unless the parties have been apart for greater than 12 months, we are required to wait for 30 days before we can submit it to be signed by a judge. As of 4 or 5 months ago, a party seeking an uncontested divorce would go with me or my associate Bailey up to the courthouse, and they would give testimony in person with a witness on their behalf. In the context of COVID, and I promise that is the only time that I will mention that henceforth, we are now allowed to do divorces by deposition universally, which means that the party and their witness sign an affidavit that says what they would have otherwise said in court, and that is used as the basis of granting or denying a divorce. This simplifies and streamlines the act of obtaining an uncontested divorce. To be candid, no matter what attorney you're talking to, an uncontested divorce will never make as much as a contested divorce. But the reality is that an uncontested divorce is the best way to go for virtually any marriage whenever it comes to an end. And you will have a much higher chance of walking away with the ability to co-parent your children and to function together to the extent that is necessary in the future. If you are considering an uncontested divorce, please give the Troutt Law Firm a call. All consultations are free, including on uncontested divorces, and we will get it done in an efficient and decent manner. Thank you.